Welcome to Hull on Estates, a series of podcasts for the Canadian legal community dealing with issues and insights surrounding estate planning in Canada. Hosted by the lawyers of Hull and Hull, the podcast will touch on some key considerations when planning estates and wills. Now, here are today's hosts.
Hello, I'm Natalia and Angelini.
And I'm Lahn.
Welcome to Hull on Estates. You're listening and watching episode number 677. Today, we're going to be discussing a very recent decision called Marcy and Marcy. And Mark, do you want to take it away?
Yeah, so I'll go through some of the facts of the case. And I think this is a motion that we'd probably file under things not to do. So it's a good, kind of cautionary tale on a few different issues. Number one is the use of cautions, and number two is just the application of Section 9 of the Estates Administration Act. So just briefly on the facts of this motion, the estate trustee had brought an urgent motion with short notice because there was a pending sale on the estate residence, which it seemed like it had taken quite a few steps in the litigation to actually get to that step. There have been previous orders for vacant possession. There had been a previous order removing the respondent, who was the person who registered the caution, as a state trustee. So this was fairly protracted estate litigation at this point. And the applicant and the respondents, two brothers, both beneficiaries of the estate. And essentially what happened is the one brother, who had been removed as a state trustee, just a few days before the sale of the estate residence was to go through, had registered a caution on title to the property to prevent the sale from going through. So the estate trustee comes in and brings this urgent motion to try to get that removed, and also just to get an injunction as well to make sure, because even though the brother, through his counsel, had voluntarily removed the caution, there was still a concern that perhaps he would bring another caution or he would take some other step to impede the sale. So the purpose of the motion was just to determine, was the registering of the caution valid and what was the basis for it? And then also just to, like I said, for this injunction to make sure there was no issues with the sale. So those were kind of the two issues that the court was considering. So Natalia, I don't know if you want to go into maybe some of the discussion on the use of the caution in this case and whether the court found that that was justified.
Yeah, Mark, I was going to say it is no question a cautionary tale because, like we find ourselves when we're advising our clients who are considering having a caution registered on title, even though, a caution lasts for about 60 days. If you've got an imminent closing, it can potentially cause significant damage, right? And so we try to be careful and warn our clients about that risk. And oftentimes parties will lift that caution and negotiate terms regarding that sale going through and the money's being held in trust. And I glean in this case that wasn't happening because the brother that placed the caution on title was living there. So, there's the kicker, right? He wouldn't want this closing to go through, but then he's the risk of this massive damage award potentially, right? If you lose the sale and then time passes and the home can't be sold for the same price down the road and legal costs, etc. So I'm sort of digressing a bit into why you have to be so careful in these kinds of scenarios. But moving to the court's reasoning here, it was kind of a slam dunk motion for the executor because the court is saying, look, the brother that wants to stay in the home, he's trying to rely on Section 9 of the Estates Administration Act to defend his position, to say, hey, Section 9 says if property isn't distributed within 3 years of death, it vests in the beneficiaries. So it wasn't so unreasonable for me to have a caution placed on title. But the executor is quite rightly showing the court Section 10 of that act, which says, nothing nothing in this in Section 9 derogates from the I forget the exact language, but nothing derogates from any right of the trustee under the will. And when the will has a power to sell, which most wills do, the executor has that power to sell. You can't take that away. So, the brother just didn't. There was no easy answer for him.
No, that was exactly it. It was clear cut. There was a discussion about, the Court of Appeal case that's kind of on point on this, which makes it very clear. And the Court of Appeal case examines kind of the standard form wording that you'll find, copied and pasted in most wills, which allows the estate trustee to have the discretion to delay conversion. And that wording has been interpreted to say, okay, then, Section 9 of the Estates Administration Act doesn't operate in this case. And I'm sure you've seen this. I've seen this. I've seen several lawyers say this to me, like, oh, it's been 3 years, the property is automatically vested, and they've been completely unfamiliar with, the Court of Appeal authority, and even just right there in the Act Section 10, which is very clear, that the Act isn't meant to take away powers from estate trustees. It's supposed to give them additional powers. It operates a little bit on intestacies as well. So, I mean, those are the kind of things that the court considered. And the court was also very clear. This was not, early on in the estate litigation. This was like I said earlier, a few steps down the road. And it was very clear that, if the person registering the caution wanted to kind of assert these rights, or if he was asserting that it had automatically vested, like, why wouldn't he have done that so much earlier in the process? And that kind of informed the court's reasoning as far as costs. And in this case, the estate trustee was fully indemnified of his costs in bringing the urgent motion to the tune of about $10,000. So the counsel for the person registering the caution obviously learned quite the lesson on this one, as far as the appropriate use of the caution, and also just the legal foundation of doing so under Section 9 of the Estates Administration Act.
That's right. And the case it's a quick read. It's not a long case. It's a good sort of handy dandy tool for lawyers to have. And that Court of Appeal decision that you were referring to was the Di Michele case.
Yeah.
So we'll have a link to this Marcy and Marcy decision in any event on our website, so our viewers and listeners can get that information.
Absolutely.
Okay. So look, Mark, I think unless you have any other thoughts, I think that would conclude our podcast.
Yep, I think that's it.
Yeah. Okay. Well, until next time, we want to thank you for listening. I'm Natalia Angelini.
And I'm Mark Lahn.
Should you have any questions, please email us at info@hullandhull.com or contact us through the contact page on our website. Thank you.
This has been Hull on Estates with the lawyers of Hull and Hull. The podcast you have been listening to has been provided as an information service. It is a summary of current legal issues in estates and estate planning. It is not legal advice, and you are reminded to always talk with a legal professional regarding your specific circumstances. To listen to other podcasts or to leave a question or comment, please visit our website at hullandhull.com. Our theme music is Upper Structure by DJ A Kid and is courtesy of the PodSafe Music Network.